very good evening and a warm welcome to Personal Finance. I'm Kukulethu Cele. Well, estate planning may not be the most enjoyable conversation topic for a married couple, but it is an essential one. And if it's not done properly, it could lead to financial problems down the road. Jeffrey Wiseman, Head of Fiduciary at Momentum Wealth, joins me now for more. Good to have you with us as always.
Thanks.
Well, we are talking about couples as well as the financial planning that they have to do, but this particular conversation, as we stated, doesn't necessarily sit very high on the list of to have talks for married couples. But how important is it when it comes to having an estate plan and also will and testament as a married couple?
Well, I think it's very important. Obviously, one of the certainties is that we're all going to die one day. And if you die, there are obviously issues that are important to take into consideration. And being married obviously is important for you to determine what's going to happen to your assets when you die, and that's essentially what a will can do for you.
The marriage contract, does that play any role at all?
It can do. It's probably, well, it's very important. So there are different ways that you can be married. You can be married in community of property, then there wouldn't be a marriage contract. And in that case, you have a joint estate. So everybody both parties put their assets into a single pot and it becomes a joint estate and each has a half share in that. So that's very important in terms of how that would be dealt with in terms of will and on death. And then if you do have a marriage contract, you would exclude community of property. So you'd be married out of community of property, but there are also consequences that would flow from that. For example, you may choose to put the accrual system into your contract, and that also, would have an effect on how your estate is distributed on death potentially.
Let's touch on the married in community of property first of all, and if we can deal with that in isolation. Is it safe to assume there that upon death of your spouse that you will inherit everything or just 50% of their estate?
So it wouldn't be safe to assume that you would inherit everything because you only have a half share in the estate. So each person can deal with their own half share as they please. But obviously, practically speaking, in terms of dividing assets and dealing with them, it's important to consider that each one owns half of everything that they own. So it is important to do a will. In practice, a lot of couples would simply leave whatever's theirs to the surviving spouse. It's very practical and convenient, but not necessarily the case.
Just on when it comes to estate planning as well as drawing up that will, if we are two financially independent individuals, is it advisable for us to have separate wills or actually join them and kind of meet consensus halfway to have one individual document?
Look, your will is a personal document and practitioners also have different opinions. In South Africa, we obviously have the concept of the joint will is very popular among married couples, in which both couples will execute a single will to deal with both of their estates. And you can do that whether you're married in or out of community of property.
Does it make things easier that way?
It can do. Some people do it because they feel that it improves disclosure to the other spouse, but by the same token, there's nothing stopping you from doing a joint will and then you can revoke it the next day and do your own thing. So it does promote transparency. Sometimes it is easier to deal with assets in a joint will. Often practically it may be easier to have separate wills. Sometimes there may be complexities that are more easily dealt with in separate documents. And also if you have separate wills and one of the parties dies, that will relating to the deceased only needs to be submitted to the Master of the High Court for the purpose of winding up the estate and not the joint will that refers to both parties, obviously. So advantages and disadvantages and preferences by some practitioners in terms of what they prefer.
So it depends on the practitioner as well as the client as to what
Absolutely.
they want. The executor of the estate. Many people often think that it's fine to have your spouse or elect your spouse as the executor of your estate. Is that the case, or should you always look for someone neutral?
Well, estate administration is it's a specialized process, and it's very unlikely that a lay person would be that effective in winding up an estate if it's the first time that they get involved with it. Doesn't mean to say that you can't nominate a spouse or a friend or a trusted advisor as an executor, but more often than not, the Master of the High Court will require that somebody with knowledge and expertise assists in the actual process. And certainly from our point of view, whether you choose an attorney who's knowledgeable on the subject or a trust company, it is important, I believe, to get an expert involved in winding up the estate. They certainly know the ropes, they know what to do, they know how to deal with the various institutions, and that will ultimately end up speeding up the process, which is what you want at the end of the day.
Exactly. You mentioned trusts. Is that often an option for married couples?
Trusts can be used. Trust is a concept. There are different types of trusts. So you can create a trust, and most people do create a trust in their will to provide benefits for minor beneficiaries if they receive directly from the estate. And those are very worthwhile to do in a will. If you don't have a trust and a minor inherits, then cash would be paid into the guardian's fund, which is administered by the master. And so it may be difficult for the family and the minors to gain access to those funds. Whereas if you create a trust that's administered by a trustee, access to funds is much easier, and the guardian of those minors can then approach the trustees more easily to obtain access to those funds. Another type of trust is an estate planning trust, or a trust that people create during their lifetimes. And there are a few reasons that one can use to set up trust. For example, there are some estate duty benefits if you have a very large estate, but if you're going to use tax as a reason to set up a trust, there's a good chance that the law may change. You may end up being disappointed.
How significant is that change, actually? Because there's some people who have worked up trusts as a point or as a manner of avoiding tax, but now if the law is going to change, how dire could the consequences be?
Well, there are a few issues. Firstly, the taxation of trusts could become quite attractive, or they might neutralize the tax benefits of trusts. So if that was the sole reason for setting up the trust, and you've incurred all the costs of setting up the trust, administering it and transferring assets into it, and that main purpose disappears, then one really has to question whether it was the right thing to do in the first place. More importantly, though, if you've got assets, creditors, so if you're in business on your own and you need to protect certain of your assets from creditors, trusts can be very useful in as part of a broader estate planning exercise where you know that risk applies to you more than to other people. Trusts are very useful there. And then the other thing that does apply when people are going to have money over at the end of their lives and they want to transfer their wealth from one generation to the next. Trusts can be very useful in preventing family conflicts in terms of facilitating that transfer.
Exactly. What about the role of minors? You alluded to them earlier on. How significant is highlighting the fact that you might have minors in your last will and testament? Very
important. So obviously, I would think there are three main things. Firstly, to make sure that there's enough money going to the minors, and that's where a financial advisor can obviously assist in determining how much they need. If both members of a couple, both parties die, they would need to nominate guardians for minors, and a will is a very good place for you to nominate a guardian.
Just on a guardian, does it need to be someone who will legally adopt or look after your children, or?
It would be somebody who would be given the legal responsibility to take care of your minor children, so they would be able to then assist them, for example, in entering into contracts and all sorts of things like that. And so that's obviously an important role of a guardian. And then obviously where a will is very useful, what I've said, is that if minors are going to inherit money, to make sure that there is a trust created in the will to receive those inheritances. It makes the experience personal, and it certainly gives the family a point of contact in terms of gaining access to those inheritances.
What happens in a situation where one or the other spouse, whichever one might have been deceased, actually has children outside of the formal relationship? Do they need to get acknowledgement within the will, or if they don't, do they have any right basically to the deceased estate, even though they do have paternity to prove or maternity to prove that they are the child?
So obviously a potential liability of any estate is the possibility that one would have to pay maintenance for one's minor children. And so obviously, regardless of whether minors are taken care of in the will or not, if they were dependent or if they are minors of a deceased person, they would be able to lodge that kind of a claim. But we're talking about estate planning, and so it's very important to understand that when planning your estate, if that is something that does apply to you, it's actually important to take care of it and to understand some of the dynamics. For example, you might have a child from another relationship, and it may be very difficult for your existing spouse to come to terms with that. If one makes provision for funds to be paid to that minor child independently of the surviving spouse becoming involved, that could be quite a convenient way of resolving what would otherwise be a very awkward situation.
Exactly. We did speak to Pitnell just yesterday about the tax benefits of being married, and does some of this apply as well to estate planning and proper estate planning for married couples?
Very much so. So obviously the main thing that we speak about when it comes to deceased estates is estate duty, and estate duty, the first 3.5 million rand, is free from estate duty. So between a couple they get a combined 7 million rand free from estate duty, and to do planning around that, any bequests to surviving spouses are fully deductible from estate duty. And another tax that's also lurking, it's been around for quite a few years now, is capital gains tax. So depending on how you bequeath your estate, death is regarded as a disposal event for the purposes of capital gains tax. But if you bequeath everything to your spouse, you can delay the payment of that capital gains tax until the death of the surviving spouse. So very important from a planning point of view to understand that taxes may become expenses of the estate, and money needs to be found to settle those debts. So a very important part of planning is to make sure that there is in fact enough cash available to settle any liabilities of the estate.
Before we get to our takeaway points for today, what happens to an estate, or what are the consequences if one chooses to remarry, maybe based on divorce or following a death of your previous spouse?
So obviously the easy one there is if you do have a predeceased spouse and you get married again, obviously that new spouse just stands in and they would benefit from your estate either on intestacy or in terms of your will in exactly the same way. From a planning point of view, very important to review your will at that point and make sure that it still reflects your wishes. If a person gets divorced, perhaps it's less important about when they get remarried, but what happens when they get divorced. And when you get divorced, a spouse is regarded as having predeceased you should you die in the 3 months following the divorce. But after that 3-month period, that exclusion falls away. So it's very important, if one is involved in divorce proceedings or if one does get divorced, that there's a short period of time that you have to review your will, make sure that it reflects your new wishes based on your changed circumstances.
Exactly. Just to close things off, Jeffrey, three key takeaway points rather that the viewers need to leave the show knowing about estate duties.
Estate duties, estate planning, I think a will is very important for everyone to consider. It's very important as a document to execute, to determine what's going to happen to your estate when you die. If you don't have a will, you die intestate. Understand the tax implications of what's going to happen when you die. And certainly if you do have minor children, very important. A will is a fantastic place that you can make adequate provision for how they would be treated should something happen to you and your spouse.
Jeffrey, thank you so much for your time this evening. That is where we leave it for Personal Finance tonight. Well, thanks once more to Jeffrey Wiseman, Head of Fiduciary at Momentum Wealth. Well, do remember that we'd love to hear from you, so send us any of your tweets, comments or suggestions to @CNBC Africa using the hashtag Finance410 or to myself @Kukumfupi. Until tomorrow evening, it's goodbye.